Okay, hello everyone. Welcome into this very special live. I know it's the middle of the workday. A lot of you don't have a lot of time, so I'm going to get right into it. I'm Brian Festa, co-founder and vice president of We the Patriots USA. I am a civil rights and constitutional law attorney, and I want to tell you about a really big legal development that happened just yesterday. This really should be headline news everywhere, especially in the health freedom, religious liberty communities. It kind of was among lawyers, but I don't think it's made it quite into the mainstream yet. That's the Supreme Court's ruling in Mirabelli v. Bonta. So that was a decision yesterday by the U.S. Supreme Court. If you haven't had a chance to read it, I strongly encourage you to do so. But that was the lawsuit that was challenging California's policy to facilitate gender transitions in schools for minors and keep it secret from parents. Yes, believe it or not, right? You're all surprised the state of California would do something like this, right? But as horrific as it sounds, it was true that there was a policy in the schools that the staff, the teachers, had to assist in gender transitions and keep it secret from parents. Now, many parents obviously objected to this when they found out about it. A lot of parents didn't even know about it. In the case of one family, the parents didn't even find out until their daughter attempted suicide. And teachers had strong religious objections saying, listen, I'm not okay with this. I don't want to participate in gender transitions. And I don't feel that it's right to keep this a secret from these parents. So teachers and parents brought a lawsuit against Attorney General Robert Bonta in California. And ultimately, the policy was initially struck down. Then on appeal, it was put back into place. But now on appeal to the U.S. Supreme Court, it was once again struck down. And the reasoning the court used was applying not only its longstanding precedent in cases like Wisconsin v. Yoder, that parents have the primary duty to direct the care and upbringing of their children, the education of their children, but also its more recent precedent from last year, the seminal case of Mahmoud v. Taylor. You've probably heard me talk about it before. I've written a lot about it. A lot of others have talked about it. And that was the case where parents in Maryland challenged their school's policy, their school district policy, to deny religious opt-outs for LGBTQ curriculum. They said, nope, these kids have to learn this LGBT curriculum, and parents, regardless of your religious objections, you can't opt your kid out of it. They have to listen to this. And the Supreme Court said, no, that's a violation of the First Amendment. So that was Mahmoud v. Taylor. But lower courts have been restricting it. Many lower courts across the country, such as in California, even as we've seen in Connecticut with our vaccine exemption cases, have been restricting it and saying, no, Mahmoud was just about school curriculum. It wasn't intended to apply to other contexts. The Supreme Court has now made clear that that is not true. And I know there was another decision very recently where the Supreme Court sent back, just a couple months ago, sent back Miller v. McDonald, the Amish school case, the school vaccine exemption. You'll remember that case that was brought in the state of New York, where the Amish community schools wanted to continue providing religious exemptions, wanted parents to be able to use those, and was allowing them to and was honoring them, even though the state of New York had eliminated religious exemptions by law for school children in 2019. They were continuing to do it. Well, the state was levying six-figure fines on these schools. So that case recently was appealed to the U.S. Supreme Court. The U.S. Supreme Court sent it back to the Second Circuit and said, no, issue a new decision in light of Mahmoud v. Taylor. Apply Mahmoud v. Taylor. But that was just what's called a GVR order. That wasn't an explicit decision saying that the Mahmoud case should overturn the Second Circuit's ruling, that the Mahmoud case should apply in context beyond the limited context of school curriculum. It didn't explicitly say that, although it was certainly implied. Now we have an explicit ruling where the U.S. Supreme Court has said that it applies beyond this. And that's what's so important. And that's what I want to share with you today, because that applies directly. This is huge news. I mean, I know there's a lot of legal stuff to sift through, and it may not be, incredibly clear on the surface, but this is really big news. I would like to, if I can, share my screen and just share some of that decision with you. If I can find it right here. Here we go. So you should be able to see this now. This is the decision of Mirabelli v. Bonta. And I'm going to skip down to about page 5 of that decision, if you can find it online. Actually, the bottom of page 4. Likelihood of success on the merits. That's one of the key factors. There's a 4-factor test for deciding whether this aspect of the stay is not justified. And so granting the stay would be justified because of these factors. And the first is the likelihood of success on the merits. And the Supreme Court says, we conclude that the parents who seek religious exemptions are likely to succeed on the merits of their free exercise claim. That's the free exercise of religion under the First Amendment of the United States Constitution. California's policies likely trigger strict scrutiny under that provision because they substantially interfere with the right of parents to guide the religious development of their children. And it cites Mahmoud, the case I just told you about. And Mahmoud was citing Wisconsin v. Yoder, the other case I mentioned. The parents who assert a free exercise claim have sincere religious beliefs about sex and gender, and they feel a religious objection to raise their children in accordance with those beliefs. California's policies violate those beliefs and impose the kind of burden on religious exercise that Yoder found unacceptable. Indeed, the intrusion on parents' free exercise rights here, unconsented facilitation of a child's gender transition, is greater than the introduction of LGBTQ storybooks we considered sufficient to trigger strict scrutiny in Mahmoud. California's policies will likely not survive the strict scrutiny that Mahmoud demands. And it goes on from there. But this, let's skip down. The bottom of the page, under long established precedent, parents, not the state, have primary authority with respect to the upbringing and education of children, quoting one of their famous cases, landmark cases, Pierce versus Society of Sisters from 1925 and Meyer v. Nebraska from 1923. The right protected by these precedents includes the right not to be shut out of participation in decisions regarding their children's mental health. I would say, without a doubt, that if parents being forced or being forced to allow children to transition against the parents' will and having that be kept a secret, if that's a violation, then that triggers strict scrutiny analysis. Then certainly the forcible injection, the mandatory injection of a substance like a vaccine against a parent's will would similarly violate First Amendment rights and trigger strict scrutiny. And why is strict scrutiny so important? Well, because in religious exemption cases, up until now, the courts have applied a case called Employment Division v. Smith. It's a case from 1990, and it was about, actually it was a unemployment benefits case for workers for employment. It didn't have anything to do with vaccines, but it was because there were Native American workers who had been fired because they failed drug tests because they were using peyote as part of their Native American rituals. But as part of their Native American religious practices. But the Supreme Court in that case said, well, because the state has a policy that is neutral, because the law is neutral and applies to everyone. It's not like it's only Native Americans that can't use peyote. No one in the state can use it, regardless of their religion. Then they didn't see that as unduly burdensome on religion. If it's a neutral law of general applicability is what they call it. So if it's neutral, facially neutral, doesn't target any specific group, and it applies to everyone equally and is not specific to religious practice or anything else, then You don't need strict scrutiny. You don't need that analysis under the First Amendment. Well, strict scrutiny, that's very important to get to that analysis, because that forces the government to prove that they had a compelling interest for what they did and that they did it by the least restrictive means possible. That's a very high burden, and the state's not going to be able to meet it when it comes to vaccine exemptions. The state of Connecticut, the state of California, the state of New York, the state of Maine eliminated religious exemptions without clear evidence of an emergency, a compelling government interest that would warrant eliminating all exemptions in the state. The Disneyland measles outbreak, which is what they used as the justification for taking away the religious exemption in California in 2015, didn't even result from parents who used, it wasn't even caused by parents who were using religious exemptions. It was foreign tourists who were at Disneyland. It had nothing to do with religious exemptions. So they can't prove there was an emergency, public health emergency tied to religious exemptions, such that the only way to solve this was eliminating religious exemptions in schools. They're not going to be able to meet that burden, but they've been able to escape that analysis, to skirt by, because of Employment Division v. Smith. But now the court has signaled that no, there's a Mahmoud v. Taylor standard now for religion in schools. The Mahmoud v. Taylor standard says that you cannot burden a parent's free exercise right to practice their religion and their children's faith. You can't burden the free exercise of religion for parents or children in a school context. If you do place a burden, then strict scrutiny applies. So it skips over Employment Division v. Smith. This is huge. This hasn't happened any time in the last 35, 36 years since Employment Division v. Smith was decided. So that's why we're so excited about it here at We the Patriots USA. We have a case identical in facts practically. The fact pattern anyway is identical to the Amish schools case, also pending at the Second Circuit. Our case pending at the Second Circuit right now is the case on behalf of Milford Christian Church and their Little Eagles daycare and preschool. You'll recall in 2023, the state threatened to shut down that school if they continued to honor religious exemptions to vaccines, as they were doing, just like with the Amish community schools. They threatened a penalty. In case of the Amish, they actually imposed the fine. Here it was just a threat, which ultimately was not carried out because we jumped in, We the Patriots USA, and filed a lawsuit on behalf of the school. And I'm proud to say that 3 years later, that school remains open. Children still attend that school every school day, and the parents are still able to use religious exemptions there while this litigation has been ongoing. So we're very proud of that. But we intend to win this victory because now we have Mahmoud v. Taylor. So we immediately, last night, after this decision came out from the Supreme Court in Mirabelli v. Bonta, we filed a supplemental letter to the court informing them of this decision and asking them to apply it in our case, because in no uncertain terms, I mean, you saw it right there. I just read it for you. The Supreme Court has made clear now that Mahmoud v. Taylor applies beyond the context of just LGBTQ curriculum in schools. It's not limited to school curriculum. It applies to anywhere in the school, anywhere in the school building. Your First Amendment rights don't end at the schoolhouse doors. Okay. And they've made that very, very crystal clear now. Now we have this decision. The order remanding the case, the Amish case, back to the Second Circuit, that was great, but they didn't explicitly say that, you must apply Mahmoud in such a way as to overturn your decision. They didn't direct the Second Circuit to overturn their decision. They weren't as clear that it applies to demonstrate that denying religious exemptions would be a violation of the First Amendment's free exercise clause. I think this case makes it even clearer, this ruling yesterday, because they specifically said you can't limit it. All right. And that was one of the main reasons our Milford Christian case was dismissed, was because the district court said that Mahmoud did not apply in this context. Even though we had filed a supplemental brief after Mahmoud came out, the district court refused to apply it. But now the Supreme Court is saying you have to apply it. They've really said it twice, in the Miller case, the Amish schools case, and in this Mirabelli ruling yesterday, that you have to apply it beyond just school curriculum cases. That's a really, really big deal, folks. Watch this closely. We're going to continue to fight. Like I said, we immediately last night filed this supplemental letter with the Second Circuit. We're going to keep you updated on that. If you can, please support our ongoing efforts to fight this atrocity. This is really, it's a civil rights violation. It's a human rights violation, in my opinion, to deny a basic fundamental right of an education to parents, to discriminate against them because of their faith, because they have an opposition to one or more vaccinations. It's really, something you wouldn't have thought you'd see in the 21st century. Most people thought, well, that's behind us. That kind of discrimination, separate but equal, which was, obviously found to be unconstitutional in the Brown v. Board of Education case. This is a long time ago. That was based on race, but this is based on religion. This is saying if you have certain religious beliefs, you're not allowed in the schools with the rest of them. And it's really, really disgusting. And we are closer than ever to getting that final ruling to restore religious exemptions, not only in Connecticut, but in California, New York, and Maine. We do have a case in California for a child as well who was kicked out of school for using a religious exemption. We're going to file this supplemental letter with the Ninth Circuit as well. So we're fighting both battles simultaneously on both coasts. Please support our work. WeThePatriotsUSA.org. You can go there and make a gift. If you can't, even just $5. If everybody pulls together, that would help us. These lawsuits are extraordinarily expensive. I can't tell you, over the years, how many tens of thousands of dollars we have spent in fighting these battles. We're going to continue to do so no matter what. But obviously, it makes it a lot easier if we have help from our supporters. We're going to see this through, though. We're going all the way to the Supreme Court. We're not going to stop until we have won back religious liberty for each and every family and give every single parent the right to refuse. Because no parent in the United States of America in 2026 should be told that their child cannot attend school because they don't have the right religious beliefs, because they have the wrong beliefs. That is absolutely atrocious. And it needs to be stopped. It needs to be stopped now. So I see there are some questions and comments coming through. Actually, it's mostly just comments. Christina says she has a 1 and a 3-year-old and is thanking us for this live. She's a baby in this fight. Well, welcome, Christina. We welcome babies and OGs alike. I'm not quite an OG. I'll leave that to the people that started this, 40, 50 years ago. But I've been in the fight a while. Pre-COVID, we'll say, for a few years before COVID, I was involved in the health freedom fight. I fought against the religious exemption repeals in New York and Connecticut. Unfortunately, those were unsuccessful, but I also joined in the fight in Trenton, New Jersey, which was successful, to push back against that repeal. I went there, and they call it the Battle of Trenton now. It's known as. I was involved in that directly as well. And unfortunately, they're threatening it in other states because of what Robert F. Kennedy Jr. is doing at HHS and the CDC. These blue states are pushing back, and I believe they're going to try to repeal the religious exemption in even more states, like New Jersey, like Massachusetts, like Rhode Island. I don't think it's stopping here, folks. They've already shown they've developed their own public health alliances. You've seen that, the Northeast Public Health Alliance, the West Coast Public Health Alliance, these coalitions of states that are creating basically their own regional CDCs to have their own guidelines to keep in place the vaccine schedule, even though it's been changed, even though Kennedy CDC has changed it, has changed the recommendations. They're saying, no, we're not going to do that. In Connecticut, they're actually trying to codify it. They're actually trying to put the old vaccine schedule into law and give the public health commissioner authority to add whatever vaccine she wants to the schedule. Really, really bad things going on in Connecticut, but it's happening everywhere. And so we need to absolutely push back against it. So Janelle asks, how long do you foresee this going on for going forward? Well, honestly, Janelle, I'm hoping this is rather quick. I'm hoping, we were on track to have a hearing at the Second Circuit by the end of April. That's the estimate we originally received. However, we have not been given an exact hearing date, so that could be pushed out. But I'm hoping within the next couple months we have a hearing on this and that we get a ruling in our favor. If we don't, we'll immediately apply appeal to the United States Supreme Court. And in light of their repeated decisions, sending these cases back and making clear that Mahmoud does apply outside of the school curriculum context, I don't think they're going to be too happy if these circuit courts continue to rule against us on this issue. I think the Supreme Court is primed and ready to take up this issue and to rule in our favor. I do not think it's a stretch to say that before the end of the year, we could have a decision. I don't know if it's going to happen before the end of the school year. I'm not saying that, but before the end of the calendar year, I don't think it would be a stretch to say that the Supreme Court could take this issue up once and for all. And I believe if and when they do that, we're going to get a victory in our favor. Of course, I'm estimating. I can't give exact dates. I'm not the court. I don't make the decisions as to when these hearings are held or which cases get taken up. But I'm estimating that given that there's so much momentum now behind this, and because the Supreme Court issued the Mahmoud decision last year, it was very clear that parents do have First Amendment rights in schools. If schools deny those, that strict scrutiny applies. That's huge. Because again, they've been able to skirt by with that Employment Division v. Smith case and say, well, you don't need to use strict scrutiny. You don't have to show that there's a compelling interest. You don't have, well, no, they do now. Case in point, they're running scared on this. We have a case, and there's another case as well, in state court in Connecticut for, again, to challenge the repeal of the religious exemption for school vaccinations. But that state case is based largely on the Religious Freedom Restoration Act in Connecticut, which would require the state to show that there's a compelling interest and that they did this by the least restrictive means. They achieved the compelling interest by the least restrictive means. Well, as soon as the court denied in the other case, again, we have our case and another case, but in the other case, there was a hearing and there was a motion to dismiss by the state. As soon as the judge, just last week, I think, denied the state's motion to dismiss and said, no, the Religious Freedom Restoration Act, does apply. We're going to have to move forward under that analysis. William Tong, the Attorney General of Connecticut, immediately went to the legislature and said, let's pass a law to make an exception, to change the Religious Freedom Restoration Act in Connecticut so it doesn't apply to vaccines. Because he knows that and he's the one that represents the state in the case, his office represents the state, represents the defendants. He knows full well that if they're forced to prove that there was a compelling interest and they did it by the least restrictive means, that they're going to lose. Because why else would he rush to try to change that law? If he thinks they're going to survive strict scrutiny very easily and they're going to still win, if he thinks that they did have a compelling interest and they did it by the least restrictive means, why would you need to change the law to carve out an exception to say that the Religious Freedom Restoration Act, that strict scrutiny doesn't apply in cases like this when it comes to vaccine exemptions in schools? Why would you rush to change the law? If you think you're going to win on strict scrutiny, if you think you can prove that you can meet your burden, you would need to change the law. So that's proof positive to me that the state knows they can't meet that burden. And how diabolical is that? That's basically an admission. They know that they did not do this. They didn't have a compelling interest for doing this, and they didn't do it by the least restrictive means. Either or both. If either or both of those things is true, they lose. And they know they're going to lose on that analysis. And so that's really, really clear proof. So Barbara, hi, Barbara. I know Barbara from our time back in Connecticut. I'm no longer in Connecticut, but she's a freedom fighter in Connecticut for a long time as well. The Amish case in the Second Circuit, that's the one I referred to. If you just tuned in late, I did discuss that during this broadcast. That is also pending at the Second Circuit along with our Milford Christian case. So both cases, nearly identical fact patterns, are pending before the Second Circuit. I don't know if they're going to file a supplemental letter as well. I'll leave that to them, their attorneys. But we filed one last night as soon as this Mirabelli decision came out, because it was such a big development. We just had it immediately filed last night. And we're really, really hopeful that the Second Circuit is going to, now apply Mahmoud in such a way as to overrule the district court's dismissal of our case and deliver us a victory for religious exemptions in the state of Connecticut, which ultimately would apply also in New York if it's the Second Circuit. Remember, Second Circuit includes Connecticut, New York, and Vermont. So all three states would be covered. Yes, Debbie, I am well aware of HB 5044 in Connecticut. And that's what I just mentioned. Again, maybe you joined a little bit later, but just a few minutes ago, I mentioned that they're trying to pass a law in Connecticut to make the vaccine schedule, really the old vaccine schedule, law in Connecticut, to codify it into law, and to also allow the public health commissioner to add whatever vaccines or other mandates she wants. And that's really, really concerning. She's been a strong proponent of vaccines and vaccine mandates. Manisha Jithani, a doctor from Yale, who is the public health commissioner in Connecticut. I'm well aware of it because, again, I spent 44 years of my life in New England and a lot of it in Connecticut. And I only moved out of there about 4 years ago, a little less than 4 years ago, but I still stay in very, very close touch. I'm in Idaho now. That's where our business is based now. But we do a lot of work still in Connecticut. A lot of our legal work is in Connecticut, and we're very, very closely tied in with the health freedom community in Connecticut and everything they're doing there. We don't personally get involved in legislative action because we're a 501c3 organization. Our focus is on litigation, lawsuits, but I'm very much aware of what's going on there. I very much, I very much stand with you in your fight for health freedom and for religious liberty in Connecticut. Cora asks, so is it Mahmoud that is the breakthrough that will guarantee? Really, I'm saying it is sort of, but also the Mirabelli case that came out just yesterday. That's why this is such big news today, because the Mirabelli case that was issued yesterday by the Supreme Court said that Mahmoud does apply outside of the school curriculum context. Courts in California, Connecticut, and elsewhere have been restricting it since it was issued last year and saying it only applies to school curriculum, to public school curriculum. The court very clearly yesterday said, nope. It applies beyond that. Parents have religious liberty in schools, period. They have the right to direct the education and the upbringing of their children, not the state. They are the primary caregivers, not the state. The children don't belong to the state. And the court was very, very clear about that in yesterday's decision, which was great to see them use that kind of no-nonsense, unequivocal language. And because of that, I think because whenever a decision is issued and it's specific to a set of facts, as it usually is, unless the court explicitly says in that decision this applies in all these other contexts, what lower courts would do is say, okay, we know we have to follow the Supreme Court, of course, but we're only going to apply it narrowly like they did. We're not going to just assume that it applies to all these other places. And there's some wisdom, all these other situations. There's some wisdom in that because obviously if the court doesn't explicitly say it, you don't want to assume that it applies in every other instance, even if it's not similar. However, the Mahmoud decision was pretty clear about religious liberty in schools. The Mahmoud decision, although it didn't explicitly say it applies beyond school curriculum, was pretty clear that parents don't lose their rights to First Amendment protections at the schoolhouse door. And in fact, it said in Mahmoud, there's a line in there, which was a great line. I'm paraphrasing, but it said that, it wouldn't be much of a right. Religious freedom wouldn't be much of a right if it didn't follow a child into a public school classroom. All right. So yes, they enjoy the same religious freedom in a public school classroom as they would outside of school. So to me, that's pretty clear that anytime religious liberty is infringed upon in the classroom, that the Mahmoud analysis would apply. But the courts, again, they were able to get around that because the court didn't explicitly say it applied to things like vaccine exemptions. So they were able to say, well, it didn't apply. We're not going to apply it. The court's making clear that strategy isn't going to work. That kind of decision, they're not going to uphold that decision saying, well, you can just sort of ignore Mahmoud unless it's specifically on point with curriculum, LGBTQ curriculum. No, in this decision, they said clearly it applies beyond that. And that's why this new development really opens the door, I believe, wider than it's ever been for us to to win this fight. Um, yes, and they're trying to also make the vaccine mandates apply for adults in Connecticut as well. Really scary stuff going on in Connecticut. I really feel for you. And again, I stand with you. We stand with you. We will continue to fight for you. Doesn't matter where in the country we are, we're going to continue fighting for Connecticut and California and New York and Maine, all these states that have lost their right to refuse. Liz says, so does this decision help protect homeschooling as well, that parents have the ultimate say in how we raise our kids, or does this just apply to schools? Great point. Great point, Liz. In Connecticut, I don't know if you're in Connecticut, Liz, but in Connecticut, they're attacking homeschoolers too. That's another bill. I believe it's a Senate Bill 6 or something. There's a Senate bill that was introduced to regulate homeschooling, to make it, if you withdraw your child from school to homeschool, that you have to report as filed with DCF. And DCF has the right to investigate, to oversee that. That's the Department of Children and Families. Horrible, horrible, horrible proposal that would violate parental rights, and really, really scary stuff going on in Connecticut. But yes, Liz, the short answer is yes. I believe, it's my opinion, that this does absolutely apply in the homeschooling context as well. And if this legislation passes to restrict or further regulate homeschooling, we will be looking at lawsuits there as well. We have a great attorney that works for us, Cameron Atkinson. He does work for us, I should say, in Connecticut. A lot of our legal work in Connecticut. I'm not there and actively practicing anymore in Connecticut, although I do still have a Connecticut law license. I practice now in Idaho, so I'm kind of exclusively, outside of the state of Connecticut here. But it doesn't mean that, obviously, our organization, We the Patriots USA, is not still heavily involved. We do have Connecticut attorneys that we rely on to do this wonderful work for us in the state of Connecticut. There are boots on the ground. So certainly reach out to us. If this homeschool legislation passes, and we'll be, trust me, if that happens, we'll be all over it. We'll be making an announcement. We'll be making announcements. We'll be looking for plaintiffs. We will absolutely be looking to file a lawsuit against the state of Connecticut to challenge this, because of Wisconsin v. Yoder, because of Mahmoud v. Taylor, because of Mirabelli v. Bonta, that have all said that parents have that right to direct the upbringing and education of their children. Under long established precedent, I'm reading from yesterday's decision again, under long established precedent, parents, not the state, have primary authority with respect to the, quote, upbringing and education of children, end quote. All right. And so that's crystal clear. That's as clear as you can get, that absolutely parents are in charge. As we used to say with the signs we held up at the Capitol, remember, parents call the shots. I don't co-parent with the government. Remember those signs? You might have to be breaking them out again. In fact, I'm sure you already have been breaking them out again. Brandy, great question. She's asking how you can support and help this movement. We, the Patriots USA, we are leading this charge to restore the religious exemption in Connecticut and California and beyond. And we do have, as a nonprofit organization, obviously, we have a link on our website where you can make a donation. I don't care if it's $1, $5. If you can give more, great. But whatever you can give to join the fight, to support our efforts, we greatly, greatly appreciate it, because that's really how we're funded. We are not some private law firm. We don't charge client fees, so we don't get any money. When we take on a case, the clients don't pay us anything. The plaintiffs don't pay us anything. The only way that we survive is through donations, public donations. We don't have any angel investors, any private streams of income. Don't have any of that. It's all just public donations from people like you that want to support the fight and want to donate even just a little bit to help the cause. So we get a lot of people donating a little bit, and I only see, about 30 people watching right now. But that might only be on Facebook, maybe across the different platforms. We have more than that. And people will watch later too. It's during the workday right now, so people will watch later after they get out of work and things like that. Anyone watching this, if you can just give even just a couple dollars, whatever you can give. We know times are hard. Our funding has dropped too because times are hard, because people just don't have it anymore. But this is a vitally important fight. This is going to protect your children, your grandchildren, your great grandchildren. I mean, I can't stress enough how important this is and how long lasting legal precedent is. That's the thing. Legal precedent, it's not like elections. Elections, great. We can get behind a person, maybe. We don't agree with all of what he says, but we get behind him. You can vote for him, elect him, and that's great, but they're only in there for 4 years. And then after 4 years, you get someone who's the complete opposite and undo all of that. Supreme Court precedent isn't like that. You notice the Supreme Court there was quoting cases from 1925 and 1923 still as binding precedent. That's over 100 years ago. And they're still quoting those cases as binding law. That's why a legal fight, in my opinion, that's where I choose to invest my efforts, my resources, is in litigation. Litigation is long lasting. It's not going to go away in the next election. It's going to stay. They're going to be more permanent victories. That's not to say a Supreme Court case never gets overturned. We saw that, obviously, recently with Roe v. Wade and the Chevron case a couple of years ago, but it's actually pretty rare. And more often than not, the precedent stays on the books for decades, if not centuries. I mean, we have binding precedent in this country from 200 years ago from the Supreme Court. That's still good law. So, I mean, to me, that's lasting change. That's change that's meaningful and lasting. That's not an executive order that can just be undone by the next president. So anyway, yeah, there's a hearing on that homeschool legislation today. Yes, Liz, I heard about that. See, I've got my finger on the pulse, ladies and gentlemen. All right, thank you for tuning in. I am not going to stay on too much longer. It's already longer. I wanted to keep this under a half an hour. I know, again, it's the middle of the work day. I've got to get back to work too. This is my work, but I have other work to do. Drop questions and comments in the comment section, though, because even if you're watching this later today or tonight or tomorrow, I'll check back from time to time and look at these comments and questions and do my best to answer them. You can always email us as well at info@wethepatriotsusa.org. And let me just one last time put up the banner there so that you have it. wethepatriotsusa.org. You have the website right there. And that's our website. You can find out about all of our legal work. You can subscribe for emails to stay updated. So when there is an update from the court, you'll immediately get that email. You can sign up for text alerts. If you don't check your email too much and you'd rather get a text, we don't text a lot. You know, even unless something big is going on, unless we have a major announcement, maybe during our year-end appeal for giving, we'll send a few texts. But generally, most of the year, we don't send texts. And if there's a major event we're doing or a major legal update, sure, we'll send one that day. But you might not get a text from us for 3 or 4 weeks. And then you'll get another one when something happens. So I know people are hesitant. I don't want to be my phone blown up. Your phone's not going to blow up. Not from us anyway. We don't spam we don't spam people. We don't believe in doing that. That's a good way to scare away donors. That's not a good way to get donors. But obviously, when there's an important legal update or even this broadcast today, because I wanted everybody to know about it, I did send a text. You may have gotten a text. Maybe that's why you're watching right now. I let people know, hey, I'm gonna be coming on. We got an important legal update about the fight to restore religious exemptions. You should be aware of it. And so you can tune in or you can watch later. So yeah, you can go there, subscribe for email updates, check out all of our news on that page. And again, if you feel so moved, make a donation to support the cause. That's all for now. Thank you all for listening and watching. And again, stay tuned. We got a lot of amazing things happening. God bless everyone. Have a great day.